Welcome, everybody. This is Jennifer from Weinberger Divorce and Family Law Group. Thanks for being with us today again. And today we're going to be talking in our webinar about military parents here in New Jersey and how custody and parenting time relates to them and how it relates to federal law and branch policies differ. So we're going to talk about that today. Perhaps you're wondering if you are a military parent, how federal laws, how New Jersey law, and how your specific branch policies can affect child custody and visitation while you're either here or perhaps deployed. So let's get going with this. Of course, our disclaimer, please know that this presentation contains general information and legal advice. Be sure to direct your specific questions about your own situation to an attorney. Weinberger Law Group is not affiliated with the United States military. Talk to us. Give us a thumbs up when you find this information useful. Don't forget, we are live right now, so feel free to ask us questions by leaving us a message in the chat box below. I'll do my best to answer them while we're live. If not, feel free to send us a direct message and we can answer your questions afterwards. So what are we going to cover today? Well, first we're going to go through an introduction and some common procedural issues with regard to child custody and parenting time. Then we're going to talk about child custody and parenting time here in New Jersey and how it relates to military parents. And then we're going to have hopefully some time for some questions, but we will be providing you with some additional resources for more information when we're all finished here today. So military parents in New Jersey, an introduction and some common procedural issues. So just as an introduction, we want to just let you know that issues involving child custody and visitation or child support can be a little bit more complicated for military families due to that interaction of state family law and military regulations. Now, state courts, New Jersey courts, make their own orders based on state law rather than enforcing military branch policies. It moves to result in confusion regarding which state has jurisdiction. So if you're based in New Jersey, but you have to move to Virginia for an assignment and then move from there and move again, there can become confusion surrounding the jurisdiction of who is in charge of your custody or parenting time case. And there are certain laws that provide special protections to military parents, and we'll go into that a little bit more. So choosing the right court and procedure, this goes to jurisdiction that we just talked about a little bit. Depending on your circumstances, the appropriate state court may be in your state, in your child's other parent's state, or the state where your child has been living. Now, jurisdiction is what gives the court the authority to make decisions in that state. And here in New Jersey, any claim regarding custody or parenting time is filed in Superior Family Court. So jurisdiction for child custody and visitation. Where is your case going to be heard? It's governed by a very long statute called the UCCJEA. Now, any state can claim jurisdiction over your custody or parenting time matter if your child has been in that state living for 6 months. Then that state becomes the child's home state. Now, in the best interest of the child, for the state to have jurisdiction where the child has a significant connection, makes sense, right? Because, you want a court making decisions in New Jersey if your child has always lived in New Jersey. You don't necessarily want a state that has your child having that judge make those determinations. The court can also take jurisdiction if the child is present in the state, may or may not be their home state, but perhaps the child was abandoned there, or there's some sort of abuse and the child was brought there in an emergency situation. Or the child can take jurisdiction if no other state has jurisdiction. So say there is no home state, there's been a lot of moving around, and it is in the child's best interest for that particular state to exercise jurisdiction. Continuing on with jurisdiction, the original court generally keeps jurisdiction. So if you have the family court here in New Jersey handling your case, typically New Jersey keeps it unless the child moves or both parents have moved out of the state and there's a mutual agreement to change jurisdiction from one state to the other. Now, even if the child is a U.S. citizen, this is important, jurisdiction could belong to a foreign country. So if your child goes along with you on deployment and you're in here, there might be a jurisdictional issue on who has the power to make decisions regarding custody and parenting time. Now, New Jersey law states that if a child is living out of the state on a temporary modification order, so there's been a temporary change to custody, New Jersey will retain home state jurisdiction. So if it's just, for a period of, 3 or 4 months that the Jersey law states that we here in the Garden State will retain home jurisdiction. So what if there's an order for custody or parenting time from another state or another country? Well, only one court can have jurisdiction at a time. Other state courts recognize and enforce orders from the state that had jurisdiction, but they won't change those orders. You have to go back to the original state in order to change an order. So have an order in New Jersey for a month of parenting time in the summer, and you live in Virginia, Virginia will enforce that order, but Virginia won't change it from 1 month to 2 months. You'll have to go back to New Jersey to make such a change. If you have an international jurisdiction dispute, that can get really, really murky. Consult an attorney who is familiar and experienced with international custody or parenting time. Providing notice to the other parent and how we go about doing that here in New Jersey. You have to give the other parent a chance to respond to whatever it is that you're filing for in court. So if you file an application because you now want to have joint legal custody of your child, the other parent has to know that you've done that so they can respond accordingly, and you have to follow the rules on how to serve properly. Now, sometimes mail service, regular and certified, that's acceptable service, but sometimes you have to have personal service, meaning a sheriff's officer or a process server can serve the papers according to state law in your child's other parent's hands. And there is also personal service on post. If your child's other parent is on a military base, you'd want to contact their commanding officer or the provost marshal and follow instructions on how to get service of process done, because obviously even sheriff's officers or process servers can't just wander around military bases. So you want to reach out and find out what the proper procedure is for personal service on post, if personal service is required. What if the parent is overseas? Service overseas obviously can be especially challenging. If you know that you or your child's other parent may be going overseas soon on deployment, try to hammer out any issues you may be having, any urgent situations. Try to address them before they're deployed so you don't have to navigate overseas service of process. Talk to an attorney if you do have to serve paperwork overseas. They'll be able to guide you on the best way to serve process in an international jurisdiction. So we talked a little bit earlier about specific laws that are put in place to protect our military service members from court actions that are possibly unfair with regard to service of process and their ability to respond to papers. So there is the Service Member Civil Relief Act that protects our service members. It's a federal law that protects those on active duty, which includes protection from default in civil suits. So what does that mean? Well, it allows military personnel to devote their full attention to their very needed and appreciated defense of our nation. So there are timeframes, special timeframes put in place for military members to respond to family law motions or complaints, and they can be extended. You know, the time frame that is available to people not in the military at the request of the service member. Protection from default means that they can't be faulted for not responding, especially if they're deployed because perhaps they didn't receive the proper service or process because of where they are. The stay of proceedings, that's a fancy way of saying that under the SCRA, proceedings can be stopped. A judge can't, as we talk, against a service member unless that service member waives their protections or the court appoints an attorney for the service member. The service member has the right to have an attorney appointed for them so that person can respond for them in their absence. Now, if that attorney can't contact the service member, or if the judge finds that the current military service or service within the past 90 days is the reason why that member isn't appearing or responding, the court will hold off and stay the proceedings for, at the very least, 90 days. Now, after that 90 days, the service member can ask for an additional stay of time given their circumstances. Asking for that, you have to include a statement from the service member indicating how military duties are affecting their ability to appear in court, and a date in the future member will be available. And the statement must also include a description from their commanding officer indicating that the military duty is preventing the appearance in court and that leave is not currently authorized for that service member to travel back to New Jersey and appear in court. Now, courts will routinely grant requests for telephone appearances for service members if they're unable to travel here to New Jersey or out of the country. So that does help, move the matter along if the service member is able to participate in the court action via phone. Now, say you are not the military member who is deployed and you need to oppose staying the proceedings. Well, the service member who is deployed has to act in good faith and exercise when attempting to arrange an appearance in court. So they have to really try and do their best to appear. So if the service member is exaggerating the difficulty involved in making an appearance, or if their personal appearance really isn't necessary for the matter to go forward, the other parent can oppose the stay of the proceedings. This probably would come up in an emergency situation regarding custody or parenting. Now let's talk about military policies and New Jersey law with regard to custody and parenting time. So just a little brief overview about custody and parenting time here in New Jersey and how New Jersey family law governs. So state law governs parenting orders and agreements in military divorce. Now, the overriding concern in any court action here in New Jersey that involves children is what is in the best of the children. And New Jersey absolutely favors frequent and continuing contact with both parents. Parents are always encouraged to make their own agreements. If you can, sit down with your child's other parent and work out your custody and parenting time arrangement, or perhaps go to a trained mediator who can help you both reach an agreement that works for the whole family. Now, as parents, you can agree on any combination of physical custody where the child is living, custody, who's making decisions on behalf of the children. Any combination that works for you and your family that's also in the child's best interest are encouraged. Now, how does this relate to what we call military family care plans? Well, the U.S. military does not allow, this is a military regulation now, does not allow single parents to enlist. In most cases, this includes parents with joint physical custody. Joint physical custody split 50-50. So parents who separate during service actually may end up as single military parents, and this can trigger certain responsibilities as far as military regulations go. All single parents who are in the military, as well as military parents married to another military parent, must have a family care plan in place. So what is a family care plan? Well, they certainly can't conflict with court. And a custodial parent, the parent who doesn't have physical custody, can request a change in a court order that conflicts with a family care plan designating another care provider. So if you come up with a family care plan that designates a person as a custodial parent, it can't conflict with an existing court order. So you have to follow along with what's already been in place. The court will consider a family plan. So the state court will consider a military plan, but it won't enforce it if it violates the rights of a parent or, again, that best interest of the child standard. It has to be in the best interest of the child. So when you come up with your family care plan, tell your commanding officer about any existing court orders that are already out there that talk about custody and or parenting time, and provide a copy of that order so you can attach it right to your, so you see that there's no conflict there. Part of the family care plan, service members must notify the commander, their supervisor, or a designated representative no later than 30 days, 60 for National Guard or Reserve, following an occurrence that creates a single parent or military couple with children status. So service member is deployed, they become separated, they're now a single parent, they have to notify their command. Within 90 days for Guard or Reserves, the service member must submit the family care plan. And active service members who move from one base to another, they have 60 days to find a short-term care provider within that new local area. Now, as far as the content of the family care plan, each branch has its own requirements, but all three have the same basic components. So in that care plan, you have to, number one, designate a short-term care provider in the event that you have to, again, move from one base to another with the child who's going to care for that child. Designation of a long-term care provider in the event that you're deployed for a longer term, couple years overseas. And details regarding how the care is going to be given. We're going to talk a little bit more in depth about that now. A non-military person or a military spouse signs the family care plan, and that person must agree in writing to take over immediate full-time care of your child at any time in the event that you are called to active duty or deployed without notice, which can happen. Now, that provider, the short-term care provider, has to be in the same local area as the service member. By contrast, the long-term care provider to be, again, a non-military person who signs onto the plan, and they must agree in writing to provide long-term care for the child or children if the service member is deployed for a significant period or is going to be on ship at sea or is going on an unaccompanied overseas tour. Now, the long-term care provider, unlike the short-term one, doesn't have to live in the local area. The plan, however, must specify will be transferred from the short-term provider to the long-term provider, including travel arrangements and who's paying for the transfer. And the additional care provisions that should be in your family care plan, well, you need the consent of the non-custodial parent, not named as the caregiver, or an explanation for why your child's other parent does not agree with the person that you named, or why they're disagreeing with any real aspect of the family care plan. Also has to include financial arrangements for both short-term and long-term separations. Who's going to pay for the child? How is child support going to happen? Provisions for financial, medical, and legal support. Who is going to be the child's primary care physician? What happens if you need an attorney for your child? Who's going to provide that? Details regarding transportation and costs for any potential relocation of the caregiver or the caregiver's family members or child's family members. So what about parenting during service-related absences? Well, deployments can be unpredictable. We talked about that a little bit, and require adjustment. Active duty can certainly increase a parent's risk of physical or psychological injuries. And a new law enacted here in New Jersey in 2013 addresses the need for really special flexibility in child custody and parenting time plans where one or both parents are in the service. You could see the citation for that law there. So New Jersey recognizes that we need extra special flexibility for these parents who lives really are, unpredictable and can require on-the-fly adjustments. For the timing of orders, New Jersey law prohibits permanent custody decisions while the parent is absent for 30 days or more due to deployment or treatment for a service-related health condition. Courts must wait at least 90 days after the parent comes back before entering any sort of permanent child custody orders or making, any sort of major changes to already existing custody and parenting time. Period of time for adjustment for the parent coming home is afforded to them. What are parents' responsibilities? Well, the parent who's leaving has to obviously tell the other parent of the anticipated time that they're going to be away, no later than the day before departure or the 10th day following receipt of notice, whichever is earlier. Now, to the extent that it's possible, the parent who's not leaving really has to encourage email communication, telephone communication, Skype communication between the child and the parent who has left for service. To the extent feasible, obviously where the parent is going and where they're to where they're deployed is going to dictate that. But to the extent feasible, it is the responsibility of the parent who stays here to encourage communication between child and the parent who's not here. Changes are temporary. Good to note that temporary modifications have to allow the parent leaving to exercise parenting time during leave and must expire automatically when the parent returns home. So once the parent returns back to New Jersey, all the original orders go back, unless the parent can demonstrate that, keeping the is in the child's best interest or against the child's best interest. So if a parent is on leave, you can absolutely change up what the parenting arrangement is, because again, that leave is probably a shortened period of time. But again, once the service ends and parent comes home permanently, we revert back to the original order for custody or parenting time. Again, that enhanced really stressed for service members. A parent cannot base a request for a change in custody or parenting time based on the parent's absence. So you can't go to court and say, I want to change custody because their ex is, now in Iraq or Afghanistan. and because of that, they want to change custody. You can't base your request on that for a change of custody or parenting time based on military service or for treatment for a service-related health condition. Now, children don't automatically stay with the non-departing parent. The court will absolutely consider other options. So some flexible options for temporary changes in parenting time plans during deployment or treatment. The child may stay with the other parent. The child actually may accompany a deploying parent. They delegate parenting to another family member, not the other parent, who has a close personal relationship to the child. Again, the court is going to look at what is in the best interest of the child. And of course, every family is different, every child's different, so the court's going to look at the facts as they apply to your particular family. Some factors the courts consider when determining appropriate changes or modifications to orders that are temporary changes will be based, again, there's that standard again, on the best interest of the child after considering all relevant circumstances, including which parent has been the primary caretaker. If the parent being deployed has been the primary caretaker, it may be in that child's best interest to remain with that parent and go to wherever it is the parent has been assigned. Now, of course, the court's going to look at what conditions the child would be facing in the deploying country. Is it safe? Are there child care facilities, school, etc.? And the court will also consider what kind of arrangement the other parent or that alternate caregiver can provide for the child while the other parent is deployed. Is it a better arrangement that the other parent can provide? Is that in more of the child's best interest? The court's going to want to look at that. Well, that's it for today. We hope you learned something and you got some valuable information. We want to remind you, don't forget to subscribe to our Facebook event about upcoming live webinars that are coming up in the future. And there is our contact information. If you would like to reach out and schedule a consultation with one of our attorneys, you can reach us at 888-888-0919. You could shoot us an email and also visit our website at weinbergerlawgroup.com.